and I suppose what I'm really asking is, I've posited an issue and a problem which I hope most of you will agree is there, but do you have any solutions for this apparent paradox that there is this demand that individuals should be given more rights to understand what is going on, but in so doing, we're actually potentially making ourselves less collectively safe?
I think we are making ourselves, and have made ourselves, and things that I have written have often reflected what I have picked up in the work that I do and the people that I speak to who may not be able to speak out as I may do. I think the government has behaved wrongly over Snowden. His helpers had access to our most sensitive official secrets, and he should have been, Mr. Miranda should have been prosecuted. I've argued that. But I do think, from the vantage point of an intelligence community, it's by no means a simple thing, because on the one hand, they want people to communicate electronically because that's how they derive their intelligence. But on the other, they don't want to be seen to be undermining the privacy of people who are behaving completely lawfully. And what Lady O'Neill says, when she says, privacy, we've got to find out what really matters to people, what really matters to them, as I understand her, in terms of their privacy. That applies if you're a perfectly ordinary person. But if you're a terrorist, for example, or a paedophile, or a sex trafficker, or a drug dealer, what really matters to you is not letting anybody know what you're doing. So it's a right of privacy for one set of individuals cannot apply to other sets of individuals. And I think that the internet, which is currently unregulated, I think does need to be regulated. And I think if it were regulated and people knew it was regulated, they would think more positively about their privacy. However, of course, the flip side of that was if it was more regulated, then there would be less intelligence. But I'm in no doubt that people have been alerted, and look at the way that, on the one hand, ISIL, we don't know where these people are and those people are, but they're busy using the internet to communicate their propaganda to us. That shows the complexity of it. I'm in no doubt that intelligence is going to be much harder to gather in the future from the internet, because people have been alerted. They thought about it for 5 minutes, they probably would have sussed out it was going on. They have now been alerted, and intelligence communities are going to have to go back to older forms of gaining intelligence. So I think your point is a very good one. I think it's a very, very complicated one, and will take many years to work out. I noticed that Sir Tim Berners-Lee, who's a passionate internet libertarian, has more recently said, no, some new kind of regulation has to be introduced for.
David Blunkett?
Yeah, just to pick Mark Field's point up directly, earlier we felt, I think collectively, that the word balance wasn't quite the right word. In this context, I think it is, because I think we're on the one hand trying to protect ourselves from knowledge which would undermine the very purpose to which we're engaged, although I think the most sophisticated of our opponents actually do have a pretty good idea of what we can do. In fact, we're trying to catch them up sometimes. But the second, and I think equally important element, is reassurance and consent from our own population. That's the essence of a free democracy, and therefore ensuring that people feel comfortable and know enough about what we're doing to feel that it's in their interests, I think is important. And that's why in my own submission I said sometimes, and I know why we do it, because I did it myself as Home Secretary for 3.5 years, we've got to try and sophisticate. We can't tell you anything because it might be a danger. That actually, I think, starts to undermine confidence and consent, because it's real old-fashioned paternalism. It is, we know, but you mustn't know.
Yeah, we will be dealing with transparency issues later in this session. There's two more questions, I think, before we move on to the next section. The first is from Ming Campbell and then from George Harth. Ming Campbell. I think the name of this was on questions of security and economic matters.
Oh yes, sorry, we have moved on rather than...
Question 17.
Yeah. Provision is made for the use of the powers available to the security services in relation, of course, to the kind of threats which are more currently in our minds. But there's also raised the issue of economic well-being. How far do you think that is justified, and how far do you think that there is a sufficiently clear definition of the circumstances in which interception may be justified for that purpose? Is the present law adequate, or should it be stronger, or indeed should there be a relaxation? Baroness,
I'll have a go at that one. I've been very struck that despite the fact that we have uniform privacy regulation in the European Union, there are very different views about what is private in different European Union states. And in, I think, a couple of the Scandinavian states, everyone's income tax return is online for the public to look at. It strikes me that that must be a very, very salutary, though not perhaps a very popular measure. It seems to me that the economic impact of having, as we have in this country, not merely the view that income tax matters are private, but that they are really very exceptionally private, is one that is striking, has its costs, its consequences, and maybe its benefits. But there is no bright line here. And when one looks at economic espionage and technical espionage, as well as the privacy of the income tax return, one can see that there could be compatible with a society where government is by consent a variety of solutions.
well, we have some experience from the point of view of members of Parliament expenses of the kind of illustration which you give.
Indeed.
But I think it's generally accepted that there is a large volume of activity in this country on behalf of countries that we might previously have been, shall we say, in a more aggressive posture, which is less to do with whether we are developing hydrogen bombs or things of that kind, and more to do with whether or not our commercial secrets can be trawled. And I wonder the extent to which you think that is something that we should be using this kind of legislation to try and protect.
If I may very briefly, the Security Service Act, as you know, specifically talks about the duty of the Security Service to protect this country from activities designed to undermine the economic well-being of the United Kingdom. And I think that is very necessary in a very precise way when it comes to the use of the internet. It's one reason I don't think it should be entirely unregulated by people who are stealing our economic secrets and undermining us in that way. But of course there is another aspect that I think will put our security and intelligence community in a very difficult position if Britain were to leave the European Union, for example. I think many people would think that would seriously undermine the economic well-being of the United Kingdom. After all, the same argument was made in the case of the Scottish referendum.
I'm not sure
I'm not sure it's the responsibility.
I'm not sure it's the responsibility of the security services to keep us in.
All I'm saying is that I think the Security Service Act of 1989 does not need changing.
Okay, thank you. George Howard.
Yeah, this is a question about effectiveness and how you provide evidence that shows that one kind of intervention is justified. And there is a real dilemma in this. Some people would argue that there isn't sufficient evidence to prove that interception techniques are effective. On the one hand, the agencies and others might argue on the other that in order to provide that evidence, they would have to reveal a lot more about techniques than would be wise in terms of those who want to do harm, knowing what their capability is. There's a variation on that, which I'll throw into the pot. Some people have argued in evidence that they've submitted, written evidence that they've submitted, that there is, even if there is a risk of some incidents, the principle is of not authorising interception is so strong that that's a risk worth taking. I wonder, the difficulty I think we all experience is, how do you have that debate? What are the terms of that debate? And how do you produce evidence that might convince people of the necessity of some forms of interception?
Can I have a go
Yes.
at answering that question? Because I think it will be and will continue to be a perennial problem, and I think it comes down to the confidence and the trust we have in the mechanisms for oversight and accountability, be that the ISC, be that the other select committees who have a responsibility for their overseeing the relevant government department, Home Affairs Select Committee, Foreign Affairs Committee, etc. There are also the independent commissioners too. You have the regulator. There are lots of different institutions which have been created in order to ensure the relevant oversight and accountability. But to the broader public, that probably looks like a mess of organisations which may not necessarily help them navigate through this information. It may not be clear that they should go to the independent commissioner on communications or indeed on interception or intelligence. It may not be clear whether they should look to the ISC or to the Home Affairs Select Committee. So I think the challenge here from the public's perspective is not necessarily whether or not interception is effective, because we may be able to see that in some cases and the summaries of those cases which can be got, or indeed from websites of the relevant police forces who wish to demonstrate how an investigation went well and what they used. Operation Crevice is a good example of that. It's rather whether they have trust and confidence in the institutions which provide that oversight and accountability in the first place.
Yeah, as a supplementary to that, I mean, maybe others might care to comment on this. One criticism that could have been made of this committee in the past, for example, was that we were a bit in the shade. We didn't necessarily, weren't outward looking, we didn't engage with the public as much perhaps as people felt we should have done. And this is a public session today. We've had one previous public session, and the intention is that we will be more out in the open. But some of the other parts of the oversight mechanism rarely, apart from in...
George, we are coming to oversight in just about 10 minutes' time.
I'm sorry.
If you want to come in, please come in then. Remind me then.
Yeah, sorry.
I think it'll be more appropriate.
I'll leave it at that.
Well, we will come back to oversight. We move on. We've just got under half an hour of the session left, and there are several important questions to raise. The first is the question of the legislation under which the intelligence agencies operate. And I'd like myself to ask, if I may, two related questions to you on this. RIPA, which is obviously the main legislation, has been described as an analogue law in a digital age. So I'd like any observations you might wish to give as to whether RIPA itself remains appropriate or whether it needs reform in any substantive way. And linked to that, even if the law under which the agencies operate is not needing to be changed, is the way in which it's interpreted by government or by the agencies themselves. Sometimes it's suggested there's too much flexibility, it's too loose, and it allows agencies to do almost what they like and still claim that it's lawful. So we'd invite your comments on these matters.
I would say that
Baroness.
Certainly the Equality and Human Rights Commission has come to the conclusion that RIPA is time expired. It needs to be reformed, and of course there is agreement in that DRIP expires in December 16. So there will have to be new legislation. That is surely an opportunity to get greater clarity about the authorization mechanisms, to make it clearer for the public. And I very much agree that a great deal of this data about information about how it is done can perfectly well be in the public domain. They don't have to know which bit of surveillance was authorized, but that there is a process for authorizing it they can know, and equally I hear that we're coming to oversight, they can know that there's a process for checking that what was authorised is what was done.
So just to be clear what you're suggesting, you say REPA does need oversight, it needs to be replaced or renewed.
REPA needs, REPA's successor needs, I think, to have simpler and clearer structures for both authorising surveillance or authorising the collection of data, and I would say for the discarding of information, and that to make it clear you have to have both the authorisation and the subsequent oversight or audit function separate and clear and independent.
Would other colleagues either agree with or in any way disagree with what we've just heard?
Well, I don't think the intention is simply to start from scratch with RIPA. I think the necessity to update is obvious. I wasn't responsible for oversight of the passing of RIPA in 2000, but I was for the introduction of the regulations, which proved to be a great deal more difficult. I mean, I think I'm on record on saying that one of my ministers had a go at this, and my son, who'd just done a computer science degree, phoned me up and said, "This won't do, Dad." And he was right. So we had another go at it. And we saw in 2006 the need to revise it. We've seen that again since, because of erosion, because of dilution, because people are pushing the boundaries all the time. Remembering that, I'd say this for the public record, that the Investigation Regulatory Powers Act was supposed to regulate, it was supposed to confine rather than open up. It was the intention was to define and confine. And I think we need to get back to that, whilst accepting, as we have during the course of this morning, Chairman, that 8.1 and to some extent 8.4 to 6 have been working. And what we need to do now is to bring it up to date and to ensure that the oversight mechanisms, including returning to it in each fixed term Parliament, actually ensures that people have confidence in it.
And it is worth pointing out that
just briefly, please, thank you.
RIPA or REPA, however we're describing it,
the Grand REPA
was introduced in 2000, pre-9/11. It was there in order to change some of the points in the Communications Act of 1985. So it was attempting to address a problem that had been identified by government. I don't think you can read, well, even Sir Anthony May says you can't read the legislation because it is pretty challenging to do so. But the codes of practice are quite clear. Sir Anthony's reports are very clear. So yes, the legislation may be impenetrable, but actually there are other ways of understanding RIPA. So clearly if we are going to review this, which we are through David Anderson and others, it is to take into account the fact that we probably need to communicate what we are trying to do with this legislation, as well as get the words right on paper.
Thank you, that's very, very helpful. Julian, you wanted to come in, I think, on the European Convention.
Yes, indeed. So I'm going to try and bring you, Rebecca, back into the conversation by referring to the European Convention on Human Rights and the UK Human Rights Act, which indicate that the interception of the content of communications is permitted only if three tests are passed: that it's lawful, that it's necessary, and that it's proportionate. And I understand this to mean that there must be a lawful purpose, which for the intelligence agencies means it has to safeguard national security, including where this relates to economic well-being or the prevention of serious crime. That necessity means that the information being sought cannot be obtained by other less intrusive means, and that proportionality means that it must be no more intrusive than is justified by the purpose of the investigation, and that it must consider the impact, as Baroness O'Neill mentioned in her earlier responses, that it might have on the privacy of innocent people, as it were, collaterally involved. So do you consider that these three safeguards are sufficient for the purposes of those two acts?
I think our position is that the safeguards that you've mentioned, which come directly from the Human Rights Act and the European Convention, are workable and appropriate. But we don't think that under REPA they are effectively and consistently applied, because you're correct in saying that they apply to systems of interception for targeted warrants for data, the content of communications for individuals, but it's not the case in relation to communications data, and it's not the case in relation to communications which are intercepted externally. And the problem with REPA is that it has been superseded by technological developments which have come latterly, and it does mean that the basis, the lawful basis on which interception must be justified is inconsistent and frankly rather random in terms of whether a particular instance can be lawfully justified.
Could you just help us by giving one or two examples of the way, in practical terms, that what should we say, that ossification of the existing regulations has become apparent?
I'm not sure I can give you a specific example in terms of cases, no. But I think for us it's about looking across the way the Act works and looking at the broad categories of interception which are not consistently regulated, if you like.
Can anybody else indicate where it might be a problem in concrete terms that would better enable the committee to grasp the anomalies that are being suggested?
Well, I'd like to answer that very briefly, partly answer the previous question, because I think they're interconnected. I was strongly in favour of there being a new law on data interception a couple of years ago. Again, where else but in Parliament, say that bill couldn't get through Parliament because of libertarians on the right, libertarians in the Liberal Democratic Party. I think that has to be looked at again, and I think one way that you get public confidence in intelligence collection and analysis is by being able to demonstrate that it's done lawfully. So I do think we need new bills, and I think there is another aspect to REPA, and I'm not referring to local councils checking up on people's bins, although I think there's some logic there, but to the increasing use by the police of communications data. Just this morning we're hearing about the grave public concerns, and I actually share them, with undercover policing in this country. If there were a greater use by the police of communications data, there would be far less of a need to have undercover policing. There always has been a need. But it needs to, police forces, we all know, are rapidly wanting to expand their use of intelligence, and this should be set out lawfully so that it can be done lawfully.
Lady O'Neill's dissenting.
I'm dissenting simply because I think that to pin it on a category called communications data is to preserve one of the things that has led to the problems with the current legislation. Communications data, I remember on many occasions listening when we were told various legislation was discussed. This was just the where and when of phone calls or email traffic. It is, of course, richly informative, and I think that that category may not be useful to us. Of course, you can't forbid its use. Among other things, it is being used constantly and intensively by commercial companies for all sorts of reasons, and not only looking, as it were, reasons internal to the company. For example, if you have a sat-nav, the information that is telling you where the traffic jams are is obtained by monitoring other people's telephones as they get stuck in traffic jams. That's an example of a perfectly lawful use of communications data, but I don't think one can say communications data as such are sufficiently uninformative and unintrusive that they can always be used.
We'll just pause for a moment till the division bell, not the division, but the bell stops.
I'm sorry, the bell obscured
the final sentence.
last word. What was your last word?
I forget what the last word was, but the thought was that communications data was not a sufficiently robust category to be something on which to build legislation now, and that one might need to go for a clearer view of which sorts of communications data are collectible and which not, with what sort of warrant.
Michael?
I'd like to look more specifically at the interception of communications under RIPA. The written submissions made to us suggest that the use of RIPA 8.1 warrants is really regarded as necessary and generally acceptable. But in contrast, the same submissions have raised questions about the use of RIPA 8.4 warrants and external communications. Obviously, one of the main differences is that under RIPA there is a lower threshold for intercepting communications involving a person or entity overseas, and that is the RIPA 4. I wondered what your views about this are, Mr. Principal. I don't know who'd like to start.
If I could just start with the thought that it is of the essence of communications nowadays that they are not located in any clear way, given that the servers, the cloud, wherever they are somewhere. I mean, they are somewhere on Earth. Mainly, by the way, in the state of Washington, where they have cheap electricity there. But therefore, the idea that you can draw a clear line between internal and external communication is now in question. I don't think one can expect to have a sort of clear system that can be understood by the public and may gain their trust if one uses a distinction that has become fuzzy.
And can I add to that? I think we have a further concern that if under a technological regime, which I'm afraid I'm too much of a Luddite to be able to specify, what you actually were looking at the destination of communications in terms of the internal and external divide. We would have a concern that a laxer regime in relation to communications which are going outside the country might have a disproportionately burdensome effect on members of minority ethnic groups living in this country.
Can I just add in the practicalities? I know then Professor you'll be able to answer that as well. I mean, obviously, if the agencies are looking at individuals within the United Kingdom, they're more likely to have specific information to operate on. If they're looking at, for instance, terrorists overseas or spies overseas, or whatever it might be, they may not be able to target it quite as accurately, and they may need, therefore, to look for categories of communication rather than targeting specific named individuals. If we don't make that distinction in terms of the two warrants, how would you tackle this particular difference?
It would be one thing to target it in terms of the location of persons, but the location of communication seems to me an uninformative idea. Many of us use...
Pause for a moment, please. Thank you.
Many of us use Dropbox or other cloud data storage devices. Does that make all our communications external? I do not know the answer to that question, and that seems to me quite fundamental. I may be in the UK, but I believe my data to be in the cloud, and I believe the cloud to be probably somewhere in the state of Washington.
Could I just... Excuse me.
Yes, David first, and then...
Only to say, I refer back to a separate but related issue that Hazel Blair's raised with me earlier, because GCHQ obviously are doing the job all the time with data from whatever source in whatever location, but there's the related issue of how we handle data that we haven't ourselves sourced, and the impact that has on individuals in this country, where in other circumstances proper authorisation and oversight would exist.
I would like to dissent very much from the view expressed on my far right, if I could. The implication that somehow communities, and I think you mean Muslim communities in the United Kingdom, would be upset if there were not this sort of very careful distinction made. I think that's quite wrong, and I think it's wrong for two reasons. British Muslims are as much at risk from jihadism as is every other person in this country, and I don't think one should make any assumptions about what they may or may not feel about security. In my own research, I've found in Muslim communities in Buckinghamshire that they regard the security service, at any rate, as an extremely important friend of theirs. So I don't think that's right, but I think on a deeper point, surely one of the things that we're seeing in the world when it comes to, let us say, IS terrorism, but also communications, is that the distinction between what is home and what is abroad can no longer be maintained in its present form. And again, I would say we need to have new legislation that recognises that. You can have people in this country who believe, wrongly in my view, but they believe themselves to be better placed as citizens of the Islamic State. Equally, as Lady O'Neill says, we can all be storing data or downloading data from other countries. So I absolutely accept the point you're making, Lord Lothian, about the two different ways of looking at data, and that, of course, these have been exploited by our intelligence community. I understand that. But this could be an example of a distinction that is no longer meaningful.
Thank you. We've only got 10 minutes left, so there's 4 specific questions that my colleagues would like to put to you. The first, if we could deal with both the questions and answers succinctly. First is Robin Butler on communications data.
I don't want to pursue that, if I may, Chairman, because I think Baroness O'Neill dealt with it adequately from my point of view. But could I just ask one question I think we ought to cover? It's been argued that some professions need special protection under the law. For example, lawyers, doctors, priests, currently controversial journalists. What's the view of the panel about that? At the moment, the Code of Practice only says special consideration should be given, and that means authorising the examination of their communications data at a higher level of seniority. Is that enough?
Special protection requires also special responsibility on the other side, and I think that a case may be makeable for professions in which the communication of data obtained in that way is well regulated. I would say the one I know best is the medical profession, but also the legal profession. If one's going to make the case for journalists, I think it would have to be a completely different case.
Well, it's the purpose. I mean, there's no argument whatsoever that RIPA should not be used to interfere with the normal activity of the journalistic profession. None at all.
But if it was for the inquiry of serious crime...
well, that would put it into the different definition. It would be for a different purpose. It would not be to find out something that you couldn't have found in other ways. It would be in order to protect us from those particular dangers, and that would apply whatever the profession. That's the point I'm really making, and was making in the Mail on Sunday.
But we've also set a precedent, say, with CCTV cameras, where we have approximately 6 million, but 750,000 are within sensitive sites, which is education or health. So I think we have got to a stage where we understand that there are some sectors which will need some sensitivity around them. But I'd agree with David Blunkett and say it's the act, it's the process of going and approaching that is important, rather than actually the law in that sense.
Ming Campbell, a question on exchanging information with overseas partners.
Yeah. Just 2 very quick points. The first is, of course, that lawyers are not compellable witnesses against their clients under the present systems, both north and south of the border. And the second, if I may, for the record, I regard the description libertarian as being something of an accolade, and I have never found it impossible to reconcile my libertarianism with my responsibilities on this committee, and indeed others, both currently and in the past, have managed to do that as well. But can I just come to the point about exchanging information with overseas partners? We do that with the Five Eyes, as I think you all know, and is now publicly recognised, but we also do it with other countries, sometimes very substantially in our interest. Are you satisfied that the present arrangements, and in particular the legal framework which exists for this exchange, is adequate, or does it need amendment? David Blunkett, perhaps?
I'm not uncomfortable with the way we operate at the moment, but it has to be on the basis of trust, and you can't legislate as to which agency our various agencies will deal with, unless they are building that by the very nature of trust. I was closest, obviously, to MI5 and their relationships across the world, including in Europe, and they had to be, I could not be the judge of what they could trust and what information they could trust to provide to other agencies. So it is quite difficult to legislate for this. I mean, incidentally, I'd like to just put on record, Chairman, that I have never ever thought of Min Campbell as a libertarian.
Thank you. If we may now move briefly to oversight questions, particularly I'd be interested if any of the panel sometimes suggested that judges rather than ministers should be the people who give authorizations. So I'd be interested to know if any of you have particular views on that question. And George Howard, you wanted to come also on oversight. Do you want to ask your point now?
I think given the shortage of time, I'll kind of try and truncate it into one question. I think Charlie made the point that the oversight landscape is cluttered, or words to that effect. Could perhaps the panel say if they agree with that description? And secondly, how might it be reformed in order to carry out the job of overseeing interception, bulk interception and other forms of interception more effectively?
Thank you. Please. Professor Glees and then Baroness O'Neill.
And I'm not going to comment on libertarianism. What I would like to say is that I think in all of this, your role is absolutely crucial. And I think it's going to become even more crucial.
Sorry, could I just interrupt? We're not actually part of that machinery. We are part of the oversight.
That what I'm talking about is oversight. And I think that who signs warrants, ministers, judges, all of that pales into insignificance if the public have confidence in what is being done in their name and for them. And it is because I believe your committee is the source of public confidence and accountability that I think your committee needs great strengthening. In my paper to you, I mentioned specific ways in which I think it could be done. At the moment, I think the public see you as being too close to the communities over which you exercise oversight. And I think if you would have more staff, more research, other people, not necessarily parliamentarians, in your ranks, I think that would all be extremely important. The public do have memories, and they know what their elected representatives may have said on this and that subject several years in the past. But basically, I think the British public deserve to be kept safe in a free society, and they want to be kept safe in a free society, and they will do what is necessary. And
can I cut you off there, because we're going to be cut off quite soon. Sure. Baroness O'Neill, you wanted to, I think, comment.
Very briefly, I think that authorization and oversight are separate functions taking place at different stages of the process. Authorization, I think, perhaps has to be quasi-judicial for complex pieces of surveillance. I don't mean that every bit of police investigation, for example, would need quasi-judicial authorization. That might be done simply by rank. But authorization needs to be, if not a million miles away, somewhat arm's length from operations. Authorization is a distinct function, and it needs to be simple enough for the public to understand what the system of authorization is, and that then comes to the oversight function. And again, we think that for public confidence that it's working, not merely this committee, but the other oversight commissioners that exist need to be well understood, and for that they need to be understandable.
Thank you. Robin, I think you have a final question on transparency.
No, I think again that's been covered. Thank you.
In which case, Charlie, did you wish to make a final comment?
Just a very final point. It depends why you want to reform the current system, and if it is to develop trust and confidence in the oversight arrangements, then a better informed and educated public is extremely important, and therefore, rather than necessarily greater transparency, I think in terms of greater accountability and oversight, there is a role for the ISC and others to play in communicating what they are doing and why that matters to the intelligence agencies.
Well, I'd like, on behalf of the committee, to thank all our witnesses for the very helpful, very informative responses. We have the benefits of your written submissions as well, and we are particularly grateful for the extra elaboration you've given us today. So we thank you, and I now bring this session to its conclusion. Order.
Thank you. Very good.
14th of October 2014. Intelligence and Security Committee, Thatcher Room, 14th of October 2014. Intelligence and Security